Chapter 5 Estates for Years. We now come to the merger of estates for years. An estate for years may merge in any estate of freehold or inheritance. Hence the axiom that terminus et foedum non possunt conster simul in una idemque persona. Hence also the more general rule that the lesser estate merges in the greater. And, therefore, an estate for years may merge in an estate for life, for the life of the party or the life of any other person, or in an estate tail, or in an estate in fee. And in those instances in which an estate for years merges, all collateral qualities annexed to that estate, as to be dispunishable for waste, and the privileges arising from these qualities will not belong to the estate in which the term for years is absorbed. In Lewis Bowles's case, it is laid down that if one who has a particular estate, without impeachment of waste, changes his estate, he loses his advantage. If a man makes a lease for years without impeachment of waste, and afterwards he confirms the land to him for his life, now he shall be charged with waste. An estate for years, be it ever so long, is less than an estate for life. Therefore, if lessee for 1,000 years grants it for life, he hath granted all his estate and cannot make any limitation over. The reason why a term for years was esteemed in law to be a less estate than a freehold for life, is thus stated in Theobald v. Duffoy. In former days all actions were real, and land being leased for long terms, and fines taken for such leases, it was usual for the lessors or their heirs to suffer common recoveries, and by that means the lessees were evicted, because they could not falsify those recoveries until they were enabled to do so by the statute, by which it was enacted that a termer might falsify such recovery, as any tenant of the freehold might do by the course of common law, where he was neither privy nor party to the same, and that notwithstanding any such recovery he should hold and enjoy his term according to his lease against the recoverer, his heirs and assigns. In those days, the terms for years were usually granted for a short time, for nobody would take long terms, because the tenant of the freehold could destroy them ad libitum by suffering a common recovery as aforesaid. Therefore those estates for years were accounted the least. Therefore if a lease be made to a person for years, and a further limitation by way of remainder to the same person for life, the estate for years will merge in the estate for life. Again, a man leased for a term of years, and afterwards took an interest for term of life, to take effect immediately, there the lease for years is extinct. But where one leases to J.N. for term of life and 20 years over, there he shall have both estates, for in the other case both are in him at the same time and together. These instances, it may be observed, illustrate the rule that the more remote estate must be as large or larger than the more immediate estate. In the first instance, the estate for years was merged because the more remote estate was for life, and because an estate for life is larger than an estate for years. And in the second instance, the estate for years was a continuing interest, because this term was the more remote estate, and an estate for life is larger than an estate for years. It follows that an estate of freehold cannot merge in an estate for years. Again, if a man letteth lands to another for life, the remainder to him for 21 years, he hath both estates in him distinctly, and he may grant away either of them, for a greater estate may uphold a lesser, but not by econverso, and therefore if a man make a lease to one for 21 years, the remainder to him for term of his life, the lease for 21 years is drowned. So, where A leased for years to B, and afterwards leased for years in reversion to C, and afterwards devised the same and other lands to C for life, to bring up A.S children, C entered and took the rent, virtute testamenti. This is a merger of the lease to C, although he was a trustee of the freehold. And so the entirety of lands held by a husband for a term of years, in right of his wife, will merge in a freehold limited to him and his wife, for the husband has the entirety of the term as well as of the freehold. As soon as the term is merged in the reversion, the rents and covenants annexed to the lease are gone. Thus, in Thorne v. Walcombe, a lease was granted, in 1759, for 99 years, if certain parties should so long live. The lessees, in 1818, demised the premises to P for 62 years, from the 25th of March, 1821, if their interest should so long continue, subject to a rent of 42 litres, and various covenants, with a proviso for re-entry in case of default. P. Had already the reversion in fee, subject to a mortgage granted by him before the last mentioned demise by lease and release, executed in 1820, to which the mortgagee was a party, P, in consideration of a sum of money, part of which went to discharge the mortgage, conveyed the premises in fee to a purchaser, to whom the mortgagees also assigned their term, and it was stipulated that the purchaser should retain 300 litres of the purchase money upon trust, that if P should pay the 42 litres rent and performed the covenants contained in the lease of 1818, the purchaser should pay over to him the sum of 300 litres. At the expiration of the term, or extinguishment of the lease of 1759, and interest in the meantime, it was held that the deed of 1818 was an assignment of all the interest of the then lessees to P, and that by the conveyance of 1820 that interest, as well as the reversion in fee, passed to the purchaser, and, the mortgage at the same time being put an end to, the term became merged in the inheritance, and consequently that as soon as the term became vested in the purchaser, P was discharged from the rent and covenants, and entitled to the 300 litres. A contract to purchase the inheritance by a person who has an estate for years in the land, will operate to extinguish the term. Though not legally merged until the conveyance of the inheritance is made, yet the term has no longer any existence so as to be divisible by will. The estate of tenant for years merged also when he became seized of the freehold by occupancy, or mere act of law. And if a tenant for years take upon himself to grant the fee, his estate for years is gone. An estate for years, however, will not merge in the freehold or inheritance when there is an intervening estate for years. Thus executors had a term of years as such, and there was a mezzan estate for years in another person, and the executors purchased the reversion in fee. Yet the first lease is not extinct, because the second lease is mezzan between the first lease and the fee simple, and it is immaterial whether the mezzan estate be for a greater or less number of years than the preceding estate. So, where A was lessee for years, with remainder to B for years, and the term of A came to the Queen, and afterwards the reversion vested in her, Clark, Baron, said that the lease of B should begin presently, and cited the case of Wriothesley v. Adams, where a lease for years is made to A, and afterwards a lease in reversion is made to B for years, and A obtains an estate for life from him in the reversion. The estate of B shall begin presently. But Manwood, Chief Baron, held that the first lease was not extinct. So, per Hales, Justice, if a man lease to one for 10 years and afterwards lease the same land for 20 years, and the first lessee purchases the reversion in fee, yet the first lease is not extinct, because the second lease, which is for 20 years, is mezzan between the first lease and the fee simple, which is an impediment to extinguishment. In Bicknell v. Tucker, it was said a lease for years, remainder for years, if the first man taketh for life, the first estate is not so determined but the remainder standeth. So also, if an estate of freehold intervene between an estate for years and the fee, the estate for years will not be destroyed by meeting with the fee. If A, tenant for life, with remainder or reversion to C, lease to B for years, or during the joint lives of A and B, A may afterwards surrender his estate to C, who has their remainder or reversion, or if the estates of A and C unite, the estate of A will merge in the estate of C. In this case, the estate of A is immediate to that of C, and also to that of B, so that A may accept a surrender from B, or may surrender to C. But while the estate of A continues, it is a mezzan estate as between B and C. And B cannot surrender to C. Nor can the estate of B be merged in the estate of C. If a lessee grant part of his estate to the lessor, by which a reversion continues in him, this is not any surrender or merger. As, if lessee for 20 years grant all his estate to the lessor, except a month or day at the end of the term, this is not any surrender, because the original lessee has a reversion. Thus, in Burton v. Berkeley, the facts were these. L. being seized in fee, demised to B for 21 years, from June, 1814, B demised to M for 21 years, from June, 1814, wanting 21 days, and then by deed poll granted to L. the indenture of lease to M. the premises thereby granted and the rent reserved to hold to L. his executors, and C. for the term mentioned in the demise to M. L. by lease and release, conveyed the premises and the reversion and reversions, and C. to the plaintiff by way of mortgage. M. assigned his term to the defendants by way of mortgage, and it was held that the deed poll from B. to L. did not merge the chattel interest in the fee, and that the conveyance in fee from L. to the plaintiff passed the chattel interest created by B. as well as the fee. If an estate for years be granted to A. and the wife of the reversioner, it shall not drown in the reversion, but upon the death of the wife previous to A. the entirety shall vest in him. When a term of years is assigned to one of two or more joint tenants of the inheritance, an aliquot part only, and not the entirety of the term will merge. Although joint tenants are sayized put out as well as per me, yet for the purposes of merger, they are considered generally as having only aliquot proportions, and so an aliquot part of the term only will be merged, if the inheritance is conveyed to or descends upon one of several joint tenants of a term. When an estate for years, and the freehold or the reversion in fee are held in different rights, the cases have established these points of distinction, viz. that where the accession of one estate to the other is merely by the act of law, as by marriage, by descent, by executorship, intestacy, and c. such accession will not occasion a merger of one estate in the other, but if it be by the act of the party, as by purchase, then merger will take place. The position of Lord Coke, therefore, that a man cannot have a term of years in his own right, and a freehold, en autre droit, to consist together, is in effect overruled. The passage in Lord Coke's commentary on Littleton is in these words: a master of an hospital being a sole corporation, by the consent of his brethren makes a lease for years of part of the possessions of the hospital, afterwards the lessee for years is made master. The term is drowned, for a man cannot have a term for years in his own right, and a freehold, en autre droit, to consist together, as if a man lessee for years takes a feme lessor to wife. But a man may have a freehold in his own right and a term en autre droit, and, therefore, if a man lessor takes the female lessee to wife, the term is not drowned, but he is possessed of the term in her right during the coverture. So, if the lessee makes the lessor executor, the term is not drowned. The position also stated in the above passage, that a man may have a freehold in his own right and a term en autre droit, is subject to qualification, and is not true of the cases in which a man possessed of a term, either as executor or in right of his wife, purchases the freehold. In the case noticed in Leonard, it was agreed that if a feme termer marry him in remainder the term continued, for it was the act at law which cast the term on the husband. And in Owen's case, it was agreed if a feme sole, executrix of a term, marry him in the reversion and dies, the term is not drowned, but the administration of it shall be committed otherwise perhaps if she had purchased the reversion. And, again, in Bracebridge v. Cook, the husband made a lease for years, the lessee granted the term to the wife of the lessor and a stranger, and the husband and wife died, and the stranger survived. It was adjudged that he should have the entirety of the lands for the residue of the term by survivorship. One of the points made in this case was, whether or no the immediate freehold and inheritance which the husband had should merge the term which the wife had in the moiety, and so dissolve the jointure between the wife and the stranger. And, as to this point, it was said the case was no other than this: if the lessor who had the fee simple married with a woman, his lessee for years, or if the husband made a lease for years, and the lessee granted his estate to the wife of the lessor, whether this should extinguish the lease for years or not, for, if it should, the moiety of the lease in that case was extinguished and merged by the immediate inheritance which the husband had in the land. And the court held the law to be, that the immediate estate of inheritance which the husband in that case had should not merge or extinguish the moiety of the term which the wife had, because he had the inheritance in his own right, and the term in right of his wife, in which case the freehold and inheritance of the husband, wherein the wife had nothing, should not merge the term of the wife. For, as it was observed, the law which carried in itself reason and equity would not do prejudice to another, and in that case the wife was other than the person who had the inheritance. And the marriage of husband and wife was a laudable thing, for which reason, the law would not prejudice the wife in her chattels real, nevertheless, that the husband might have given away the wife's term by an express act, as if he had made a forfeit of the land, or a new lease, or the like, but forasmuch as he had not done this, or anything else with the land, and had made no disposition at all of it, but had left it to the judgment of the law would preserve the estate of the wife, which estate, as to her, was disjoined from the freehold and the fee simple. And to obviate the objection drawn from the law on the suspension of rents, when the rent comes to the person liable to pay the same, it was said by the court, that which was suspended was not in esse for the time, and that which was not in esse could not be in jointure for the time of its non-existence. But in this case the land was in jointure, and was always in esse, and could not be in suspense, or want of existence, but that here were divers times in the land, viz., a lease for 70 years, and the husband, after that, had another time in the land, viz., a time infinite, which was a fee simple, which time infinite should merge any other lesser time, which the husband had singly in the land in his own right, as a time for years or for life, but that here the lesser time was not in him singly, but it was in his wife and anticle the stranger, and he had nothing in that lesser time but by reason of his wife, and then his greater time, which was infinite, should not merge the lesser time which his wife and anticle had, but it should continue for the benefit of the wife and the preservation of her interest, so that there was no suspension of time, but there was first one time, viz., 70 years in the wife and anticle, and, afterwards another distinct time in the husband, viz., a time infinite, commencing after the first time, which should not drown the first time, but the same should continue by good reason for the benefit of the wife and anticle, inasmuch as the several times were to several purposes, and tended to several benefits. And again, in Plut v. Sleep, the husband had a term in his own right, and the freehold in right of his wife by descent, and it was held that the term continued and was not merged. The resolution was that where the baron had a term for years in his own right, and the inheritance afterwards descended to his feme, that coming to him en autre droit, should not drown and extinguish the term for years, which he had, and was possessed of in his own right, and that he might well assign over or dispose of the term at his pleasure, notwithstanding the descent of the inheritance to the wife. And all the judges, except Williams, who was very strenuous against this doctrine, agreed on this point. The judges who dissented from Williams said, it was not like Bracebridge v. Cook, where the baron had the fee and freehold in his own right, and the term in right of his feme, while the case of Bracebridge v. Cook is an authority, that if a husband who has the reversion in fee afterwards becomes entitled to a term in right of his wife, the same shall not merge. In Doe v. Pett, the husband was the assignee of a term, and a moiety of the inheritance descended upon his wife, and it was ruled without argument, that the term was not merged. From the case of Platt and Sleep, Jenkins, in his Centuries, deduces these distinctions. A woman has a lease for years, she takes a husband who is seized of the reversion in fee. The lease may survive to the woman. A husband has a lease for years, and the wife purchases the fee, or the wife before marriage has the reversion. This extinguishes the lease, but not so if the fee descends to the wife after marriage. He refers to the maxims, volenti non fit injuria, quilibet petistrin non ser juri pro se introducto. All these positions, says Mr. Preston, are correct, except that which applies to the wife, who before marriage has the reversion. That proposition is contrary to the current authorities, and no case occurs which supports the proposition that a lease shall merge when a husband has a lease for years and the wife purchases the fee. This latter proposition, if law, may be reconciled by considering that the wife cannot purchase with effect without her husband's concurrence, that his concurrence is an act done by him amounting to a waiver of the term, in effect, to an agreement to give up the term and to take the freehold in right of his wife. This, however, should be treated as a doubtful point, and it is doubtful also whether merger will take place when the husband holds the term in right of his wife, and the wife purchases the reversion with his consent. But if the term which the husband holds in his own right will be extinguished when his wife purchases the freehold with his consent, it necessarily follows that the term will also merge when the husband holds the same term in right of his wife, and she purchases the reversion. In Thorne v. Newman, Baker, lessee for years in trust for the plaintiff, married a wife to whom an estate of freehold was limited of the same land. This was said to be a merger of the term, because a freehold en autre droit cannot stand with a term in his own right, though it may e converse where the same is en autre droit, according to the difference. Lord Nottingham said the difference was not clear in law, nor founded upon solid reason, for both parts of the difference had been otherwise resolved. But whatever the law be, it ought to be no merger in equity. In the cases of Bracebridge v. Cook, and Platt v. Sleep, one of the estates was an accession to the other by the mere act of law, and no distinction was made whether the reversion or remainder was an accession to the preceding particular estate, or the preceding particular estate was an accession to the reversion or remainder in fee. In Platt v. Sleep the reversion acceded to the term, and in Bracebridge v. Cook the term was an accession to the reversion, and in these and all the similar cases the exemption from merger was uniformly allowed, as the consequence that the two estates were held in different rights, and these rights as distinguished from trusts were recognized and allowed by the law, and that one of these estates was an accession to the other merely by the act of law. A descent of the inheritance, however, will merge a term which a person has in his own right at law, though he be a trustee of that term. It has lately been held that if a husband have a term of years in his own right, and the reversion be devised to his wife in fee, the term will not be merged, and that the fact that the husband had issue by his wife made no difference, for the wife being still alive, the tenancy by the courtesy was only initiate and not consummate. It seems to have been argued in this case that the reversion was acquired by the act of the party himself, and with reference to this argument the court observed, in the present case the reversion came to the wife by devise, and in her right to the husband. It is only by a forced construction of the words that this could be called an acquiring of the estate by the husband's own act. It was argued that he might renounce all benefit from the devise, and, therefore, if he took no steps to do so, he acquired the estate by his own act. But in this view we cannot acquiesce, and we are of opinion that the application of such a rule, if it exist at all, must be limited to cases of immediate acquisition by the party in whom the estates meet, and cannot be extended to a possession by a husband in right of a wife under a devise made to her. If by the party's own act anything so general be understood as was contended in the argument, it would be difficult to maintain the authority of Bracebridge v. Cook. It was there laid down, that if a man say ised of the freehold inter marry with a woman, term of a years, the term is not extinct, but the husband has possession of the term in right of his wife, and yet it might equally be argued that the marriage was voluntary, and that he therefore acquired the lease by his own act. Referring to the decision of Platt v. Sleep, the court also observed, it was there held, that the husband being termer, and the fee descending to the wife, there was no merger. No doubt was thrown upon this case in course of the argument. Its authority has not been assailed by any of the text writers, and it must, we think, be accepted as good law. The two estates may therefore consist together, if held in separate rights, one in the right of the husband, the other in the right of his wife. If a term of years be held by a husband in right of his wife, and the reversion in fee descend to the wife, it would seem to follow from the cases cited, that the term belonging to the husband would not merge, and on the ground that the descent was the mere act of law. If merger were held to take place the husband would be prejudiced, as he would not have the power to dispose of the term during the coverture. On this point Mr. Preston remarks, a descent of the fee to the wife of a man possessed of a term in her right is not precisely within the reason of the case of Platt v. Sleep. It is true the right of the husband under the term of his wife will be affected by merger, but in answer to this difficulty, it may be observed, that the term is the property of the wife till the husband shall have disposed of it. It is probable, however, that when this case shall come for decision before the courts of justice, they will incline to favor the right of the husband. The principle of the doctrine of merger, and of the exceptions allowed to that doctrine, do not appear sufficiently extensive to justify such a decision, but till the point shall have been decided it is difficult, indeed impossible, to form any certain conclusion. With respect to the wife's chattels real, it must be observed, that during the coverture the husband has a general and unlimited right of disposing of the lands for all or any part of the term, but as against his wife, if she survives, he cannot charge the land, or dispose of the same by his will. The right of the wife, after the decease of her husband, will take place of any charge he has created, or any testamentary disposition he has made. If the husband survive the wife, the term will vest in him absolutely in his own right, without obtaining letters of administration, and it cannot be doubted, but that immediately after the death of his wife, the term will cease to be privileged from the application of the law of merger, and will be affected by all the consequences of this conclusion of the law, notwithstanding the term held in right of the wife was an accession to the estate which the husband held in his own right. From the instant the wife dies the husband ceases to hold in right of his wife, and the reason of the exemption of her estate from merger ceases in the same instant, and cessante ration cessat ipsa lex. But if the wife survive her husband, then the term, or so much of the time thereof as is vested in him at his death, will again become the absolute property of the wife, exempt from all charges of the husband as distinguished from underleases, and all dispositions by his will, and the application of the doctrine of merger, as far at least as this estate is entitled to the exemption from the circumstance that the estate was an accession by marriage to an estate previously vested in her husband, or an estate which descended to him. We have stated that merger will take place if the accession of one estate to the other was by the act of the party in whom they vest as by purchase. According to Brooke's surrender, if an executor who has a lease for years from his testator, purchases the freehold, the lease is clearly extinct, and Dyer also expressly declared, that if an executor hath a term, and purchaseth the fee simple, the term is determined. In another case a man had a lease for years as executor, and afterwards purchased the land in fee, and Brooke says, the lease was extinct. In another case, reported by Moore, a married woman became entitled to a term as executrix, and the husband held the term in her right, and in right of her character of executrix he purchased the inheritance, and it was held that the term was merged so as to be extinct as to the wife if she survived, though in respect of all strangers it should be accounted assets in his hands. And Manwood declared the law to be that, if a woman term of a years takes husband who purchases the fee, the term is extinct, for the husband hath done an act which destroys the term, viz., the purchase. The same doctrine has also been treated as clear law in a case reported by Hetley, and a case reported by Freeman. In Smith v. Tracy, it is said by Saunders that, if a lessee for years, as executor, purchase the reversion, this shall extinguish the term, because it is his own act, but if one that hath a reversion be made executor, and hath the term that way, that shall not be an extinguishment, because the term and the reversion are conjoined by act in law. There is an obiter dictum of L. C. J. Holt, in Cage v. Acton, that if a man hath the term as executor, and purchases the reversion, this is no extinguishment. Upon this case Sir Edward Sugden observes, the rule that a purchase of the fee by the executor shall merge the term, appears to be founded in reason as well as upon authority, for, as far as his own interest is concerned, there cannot be any reason why the term should not merge. It is admitted, however, on all hands, that the term shall not be extinct as to creditors, and this, I am induced to believe, from Lord Raymond's report of Cage v. Acton, is all that Lord C. J. Holt meant, although his dictum is so generally stated in Commons's and Salkeld's reports of this case. At any rate, it was a obiter dictum, and cannot affect a doctrine apparently so well established, and it is therefore submitted to the reader, that in a case of this nature, the term must merge in the inheritance, except as to creditors. The case of Carter v. Lowe is to the same effect, viz., that upon the act of the party depends the conclusion of merger. There a termer devised his term to J.S., and made his wife executrix, and died. The woman entered and proved the will, and took husband, who took a lease of the lessor, and after the devisee entered and granted all his estate to the husband and wife. The question was, if by the acceptance of the new lease by the husband, the term which the woman had to another use, viz., to the use of the testator, should be considered as surrendered. And the opinion of the court was clearly that it was a surrender. And, again, where a lease was made to baron and feme for years who entered, the lessor afterwards in fifth the baron who died seized. The feme survived, and claimed the term, and betwixt the feme and heir, the debate was whether this term was extinguished. And it was held, per totam curiam, that by the acceptance of the fofement the baron had surrendered the term, and it was extinguished. The case of Lichten v. Winsmore seems to point to a conclusion, that where the party who holds the estate en autre droit, has not the complete power of alienation over that estate, as, for example, the freehold estate of a wife, a term of years will not merge. According to that case, if a man seized of an estate for life in right of his wife takes an assignment of a term on which the freehold of his wife is expectant, the term will not merge, and yet in this case he has the term in his own right, and the freehold in right of another, and one of these estates is an accession to the other by his own act. In this case there was a lease for years, the reversion to a feme covert, and the lessee granted his estate to the baron, and it was held that the term was not extinct, because the baron had the estates in several rights, for that the frank tenement was in the wife, and the baron only seized in her right, and yet the term might have been surrendered to the husband. We have seen that where the husband has a term of years, and the reversion in fee be devised to the wife, the term will not merge. This case of Lichten v. Winsmore, while being a decision contrary to Lord Coke's dictum, yet seems also to be contrary to the rule that there shall be merger when one of the estates is an accession to the other by the act of the party. The cases, observes Mr. Preston, have carried the point of exemption from merger one degree further. It has even been held, that if a woman leases for life, and having the reversion in fee, takes husband, and her husband purchases the lease for life, that the lease for life shall not merge, though the husband, in right of his wife, is seized of the reversion in fee, which is immediate to the estate for life of which he is seized in his own right. None of the cases, however, here referred to are cited by Mr. Preston. It would seem to follow as a conclusion, from the cases before cited, that when a husband has a term of years in right of his wife, and a reversion in his own right, and he makes a conveyance sufficiently operative to pass both estates, the term will be merged. The result of the cases as regards husband and wife may be stated thus: when a woman has a term of years either in her own right, or as executrix or administratrix, and her husband afterwards purchases the immediate reversion or remainder, the term will be merged, but if the reversion had descended to him, or if he had purchased the reversion or remainder before his wife acquired the term, the act of law would not effect a merger of the term of the wife. If two terms meet in the same person, and one of them be held in his own right, and the other as executor, merger will not take place, and an assignment, using the words all his estate, and c. will not vest the two terms in the assignee. It is contrary to the intent of law, says V.C. Wood, when persons described as executors assign over an estate for an actual term, vested in them as executors, followed by the words and all the estate, and c. to hold that the assignment passes also the rights which those executors hold individually for their own benefit in the same estate. The merger of terms for years in each other deserves considerable attention. The union of two actual and vested terms by means of distinct conveyances cannot, under any circumstances, give one estate of an enlarged time of continuance. A term of years derived by way of underlease out of a term of years may merge on their union. In this instance there is the relation of lord and tenant between the parties, and after the merger the original term will be in the same state in point of duration of title and right of enjoyment, except by reason of mesencumbrances, as if no underlease had been created. It is now well settled that one term will merge in another term in reversion, and it is all one if the reversionary term be for a greater number of years or not. The authorities in support of these propositions are as follows. In Hughes v. Roebuck, the plaintiff declared upon an assumpsit, stating that he was possessed of a lease for years, and that the testator was possessed of the reversion for years, and that the testator, in consideration that the plaintiff would surrender to him all his estate, promised to give him £30, and the plaintiff alleged a surrender in fact. The defendant pleaded non assumpsit, and the plaintiff obtained a verdict. One of the grounds of a motion made in arrest of judgment was, that the parties were termers, one in posses scion, the other in reversion, and that a termer cannot surrender to a termer, as it was alleged, for one term cannot drown in another. And to this point Popham said, it is clear that he which hath an estate for 10 years, may surrender to him that hath an estate for 12 years, and the estate is drowned, and the other shall come into possession, and there is no doubt but a surrender to him that hath a greater estate for years is good, as to him that hath an estate for life. This Gordy expressly affirmed, and it was added, here it standeth indifferent, if the reversioner had a greater estate for years or not, and Popham conceived that if the testator had the reversion, for a less number of years, still the surrender was good, and the estate should drown in it, and if a man be lessee for 20 years, and the reversion is granted for 1 year to another, who grants it to the lessee for 20 years, this is a surrender of the first lease for 20 years, and is as if he had taken a new lease for a year of his lessor. This was also affirmed by Justice Fenner, and he said the surrender was good, although the reversion was for a less term of years, for he observed, here are several terms out of the reversion, and one cannot stand with the other, but coming together one shall drown the other, and the number of years is not material, for as he may surrender to him which hath the reversion in fee, so he may to him that hath the reversion for a lesser term. This doctrine that one term may surrender to another, and that one term may drown in another, is admitted and taken for granted in the case of Whitchurch v. Whitchurch. The cited case of Hughes v. Roban affords authority not only for the proposition that one term will merge in another term in reversion, but also that one term may merge in another which is of shorter duration. On this case Mr. Preston observes, one of the principal objections to the weight ascribed to the case of Hughes v. Roban, is that Popham has reported the same case, and is silent on the point of merger. It is true there is not in his report any direct reference to the doctrine of the law of merger, but all the learning respecting the right of one termer to surrender to another termer who has a reversion expectant on the first term, will be found in Popham's as well as Croke's report, and the judgment in that case rested on the point that the term in possession was merged in the term in reversion. Gordy is reported to have said, he who hath 10 years in possession may well surrender to him who hath more years, as 20, in reversion, for the lesser may surrender to the greater term, and Popham and Fenner assented to this doctrine, and Popham added, though Roban had a lesser term in the reversion than Hughes had in the possession, yet the same shall be good, for in law it is greater and more beneficial for him to have a lesser term to be a termer in possession, than to have it to be in reversion. Whatever doubt remained on this subject after the case of Hughes v. Roban, was removed by the case of Stevens v. Bridges. A mortgage term of 1,000 years was created in 1720, and another for 500 years in the same premises in 1725. The former, together with the mortgage debt, for which it was a security, vested in A, and upon her death devolved upon her executors, who, in 1730, took an assignment of the 500 years term with the debt due thereon. In 1795, the executors assigned both terms to trustees on the marriage of the legatee, entitled to them under A.S. will. Sir John Leach, v. C., held that the 1,000 years term merged in the reversionary term of 500 years. The two terms must, however, vest in the same person and in the same right. Thus in Rupert v. Harrison, two terms were created in the same manner, one of 500 years in 1712, the other of 600 years in 1768. In 1791 the latter was assigned to A, to secure a mortgage debt, and by a deed of even date the former was assigned to B, as a trustee for A. A died, having appointed B, C, and D, his executors. In 1801, by a deed endorsed on the first assignment of 1791, and made between B, C, and D, executors of A, of the one part and D, of the other part, B, C, and D, assigned the premises, and all the estates, and C, to E, for the residue of the term of 600 years, subject to the equity of redemption, and the court held that the term of 1712 being held by B, in what must be deemed his own right, did not pass by force of the words, and all the estate, and C, and was not merged, whether an estate for years will merge in another estate for years in remainder, has not been the subject of any decision, but the better opinion, according to Mr. Preston, would seem to be that it will. Thus if lands are conveyed to the use of A, for 100 years with remainder after its expiration to B, for 99 years, if A assign his term to B, will it merge in B's term for 99 years, or will B have the ownership during the collective period of both terms? Mr. Preston says, as far as reason and good sense ought to prevail, and technical rules be exploded, it seems to be reasonable that the assignee of two several and successive terms, one in possession, the other in remainder, should be entitled to hold the possession for both these terms, since from the nature of these interests there is not any incompatibility between them, and the time of one estate is quite distinct from the time of the other estate. The same, however, may be said with equal reason of a term for years followed by a remainder for life, when the estate for years and the remainder for life meet in the same person, and as the law decides that the term shall merge in the latter case, there does not seem to be any well-founded reason against the merger of the term in the former case. This last observation does not seem strictly applicable, as the estate for years and the estate for life are not of the same quantity. The union of a life estate in possession with a life estate in remainder, affords a closer analogy to the case of the union of the two terms in B, and we have seen in the chapter on estates for life, that when two equal life estates, the one in possession, the other in remainder, meet in the same person, that merger will not take place. The same able writer before cited, in commenting on this point, observes, the principle, which it is submitted must govern these cases is this, that being equal estates, the one in possession, the other in remainder, either for life or for years, they may coexist as continuing interests in the same person in the same right, because the incompatible relations of dominus et tenens not meeting in the same person, do not call for the absorption of the one in the other. The same writer is also of opinion, that if the term in remainder were larger in duration than the preceding term, the above rule would keep them as continuing interests, and that merger would not take place, for the terms, although unequal in numerical duration, are nevertheless in legal designation of equal quantity. The effect of merger is very different in the case where the estate merged is derived by way of underlease out of the estate in which it merges, from the case where the two estates are distinct and independent of each other. In the first case, if A, lessee for 20 years, lease to B, for 10 years, A still continues the owner of the residue of the whole term for 20 years. The lease granted by him does not abridge his estate, it merely affects the right of possession, by transferring to another person, for a particular time, that right of enjoyment to which he himself was entitled, and on the term of 10 years becoming vested in A, it is merged in the reversionary term of 20 years. In the other case, if A seized in fee leases first to B, for 500 years, and afterwards to C, for 10 years, by way of immediate reversion, and C assigns his term to B, the estate of B will be merged in the estate of C, and the estate of C will end or determine with the effluxion of the time or sooner determination of the term of 10 years. C, as reversioner, is entitled to hold only for 10 years, and the accession of the term of 500 years will not enlarge his estate or give to it any additional time of continuance. The 500 years term is merged, and the term of 10 years is brought into possession. In the former instance, the term in the reversion does, in point of law, comprise all the time for which it was originally granted, and not merely the time which is not disposed of by the derivative lease, while in the other case, the reversionary term is merely for 10 years, and that term must cease as soon as the period of its continuance is determined, and the time of its duration must have begun to run before it can be the cause of its merging in other term. We have seen that merger will not operate to the destruction of trusts, yet the doctrine applies at law, if one of two estates be held in trust and the other be held beneficially by the same person, or if both estates be held by the same person on the same or on different trusts. Although, in point of law, merger takes place, equity will interpose, and by its interference will, as against the person who has occasioned the prejudice to the beneficial owner entitled under the trust, and all persons claiming under such wrongdoer without consideration, on with notice of the equitable title, support the trust by way of charge on the land by decreeing possession of the lands for the time of the estate which is merged, or by decreeing a conveyance, as the circumstances of the case shall require, and as will be the means of administering the most complete and effectual justice to the Cestuique trust. The law considers the extinguishment of a term through merger by an executor or administrator as a devastavat, and a merger of the term of an executrix or administratrix in the reversion or remainder of her husband will be a devastavat by the husband and wife during the coverture, and, it should seem, by the wife after the death of her husband or other determination of the coverture. But the husband is not liable for the devastavat at any time after the death of his wife or other determination of the coverture, except when there is judgment for the devastavat against him and his wife during the coverture. When the merger does take place, the term will be completely annihilated at law, as against the executor and all other persons, and equity will consider the value of the term to be assets in the hands of the executor. When a person is originally entitled to a term as an executor or administrator, and in process of time he becomes the owner of that estate in his own right, merger will ensue. This happens in the case of executors, when the executor is also residuary legatee, and he performs all the purposes of the will and holds the estate as legatee, or when the executor pays money of his own, to the value of the term, in discharge of the testator's debts, and with an intention to appropriate the term to his own use in lieu of the money. And, in the case of administrators, when the administrator is the only person entitled to the beneficial ownership of the intestate's property, or procures a discharge from those who are to share that property with him, and all the debts of the intestate are paid. Under these and the like circumstances, the executor or administrator will have the estate in his own right, and when he has the estate in his own right it will be subject to merger. The following are cases in which a court of equity has interposed to prevent or give relief against merger. In Danby v. Danby, a term was merged by fraud, and the court relieved against it. The decree was that the plaintiff, his executors, administrators, and assigns, and all claiming by or under him or them, should peaceably hold the premises during the said term of 3,000 years against the defendants, and without their interruption, and notwithstanding such conveyance there should be no merger of the term, and that the same should not be given in evidence, or any use made of it against the plaintiff, his executors, and that the plaintiff, his executors, and might assign and dispose thereof in as ample a manner as if such conveyance had never been made. In Saunders v. Bournford, a conveyance was directed, in order to do complete justice to the beneficial owner of the term. And in the Duke of Norfolk's case, Lord Chief Baron Montague said, referring to a term that was merged, "This term is gone indeed and merged in the inheritance, yet the trust of that term remains in equity. And if this trust be destroyed by him that had it assigned to him, this court, the Chancery, has full power to set it up again, and to decree the term to him to whom it did belong, or a recompense for it." In this last case it should be observed that the term was extinguished by surrender and not by merger. The following case appears in Cruise's Digest, and is applicable to this point. A. Being seized in fee, conveyed an estate to the use of B. and C. for 1,000 years, in trust for raising portions, and subject thereto to the use of himself in fee. A. By his will, made some time after the settlement, devised the estate to C. and D. in fee upon trusts, and died by the union of the 1,000 years term of which C. was trustee jointly with B. With the inheritance devised to him and D. as joint tenants in fee, merger of the term took place in the moiety of C, and a consequent severance, and the term in the other moiety continued a subsisting legal interest in B. But notwithstanding this merger of the term at law in a moiety, the Court of Chancery directed the parties entitled to the inheritance to restore the term in the moiety which had merged, and to execute such conveyances as would legally secure equitable charges upon the entirety of the estate comprised in the original term. In the case of Law v. Irwin, Mrs. Sage, an underlessee, bequeathed her underlease to her lessor, who held for a larger term, in trust, in the events that happened for the vendor, Caleb Law, and appointed the lessor her executor. It was held that the underlease had merged, but nevertheless the lessor and executor was bound to allow the vendor, as the Cestuique trust, to have the beneficial enjoyment without the legal estate commensurate with the interests under the sublease. The lessor and executor in this case assigned the property to the vendor for the residue of the term in the sublease, subject to the covenants in the underlease on the part of the lessee, and the lessor and executor covenanted that he had done no act to encumber. It was decided that the instrument was what it professed to be, viz., an assignment, because such was the intention recited, and there was a covenant by the assigner that he had not encumbered, but it was held to be void as an assignment, because the thing attempted to be assigned was absolutely gone, but it was considered that the vendor's equity to have the beneficial interest during the continuance of the sublease remained. The original lessor, who was the executor of the underlessee, died, and his executors, in order to avoid any question of the legal validity of the last-mentioned deed as a resuscitation of the sublease by a new underlease, demised the property to Mr. Law, commensurate in point of duration with the term granted by the original sublease, and upon a question between Mr. Law and a purchaser from him, it was held that the title was bad, for the lessor's executors had no authority to part with the legal estate in this way, and Mr. Law's equitable title was held to be good, but his legal title to be invalid, and the court said that the legal estate might be withdrawn from him, provided the persons who claimed under the title of the lessor thought proper to file a bill for that purpose. In Villas v. Villas, it was insisted on one side that a term of 60 years was merged by being created to the same person to whom the fee was devised, who had likewise their reversionary interest in another term, for 99 years, but it was contended on Mr. Villas' side that there was not any merger, because there was a trust of the term. The trust kept the term separate, and consequently it was not merged. When the estate which merges belongs to the trustee in his own right, or has devolved upon him by descent, there can be little doubt that his equity is as strong as that of the Cestuique trust, and the court would not order the trustee to convey till the time of his estate was expired, or without allowing him to make such a conveyance as would give him a legal title to an estate of the same extent and equally beneficial with his former estate. Thus it seems clear that if a tenant for years accept an estate of freehold or of inheritance, subject to a condition, and the condition operate to defeat this estate of freehold or of inheritance, the term shall not be restored to his estate for years, for the estate once extinguished by merger will not revive at law. Thus, in the 3rd of Leonard, it is reported that the lessor mortgaged the reversion in fee to the lessee for years, and at the day for the payment of the money, he paid the money, and it was holden that the lease for years was not revived but utterly extinct. So, in Goldsborough, it is reported that Periane said that in all cases when the freehold cometh to the term there the term is extinguished, and therefore if a man mortgage the reversion to the lessee for years, and after perform the condition, yet the lease for years is utterly extinguished. In each of these cases there is every reason to suppose that a court of equity would decree a similar term. Again, a term of years will not be lost by merger in an invalid conveyance. In the case of the Attorney General v. Carr, a valid lease of charity property, which had merged in the fee by an invalid absolute conveyance to the lessee, was nevertheless sustained on the conveyance being set aside. An executory interest in a term of years cannot be defeated by merger. Thus in Vincent Lee's case, reported by Moore under the name of Lee v. Lee, a man devised a term for 21 years to A, and if he died within the term, then to B, for the residue of that term, and the inheritance was devised to C, entail, with remainder to A, entail, with remainders over, and C, having died, the term in A, merged in his inheritance entail, and although the term was merged by its union with the immediate freehold in A, yet it was decided that the possibility of B was not defeated, but there was an extinguishment only for the time or estate of A. It remains only to observe upon the interest known interest termini and estates by extent. The former is not such an intervening interest as will prevent the application of the law of merger. Notwithstanding this interest while it continues in fieri, there may be an actual absolute and complete merger, as well of subsisting terms for years, as of estates of freehold interest. The right of possession, however, under this interest, may by merger be accelerated. Therefore, where a man made a lease, by indenture, for a term of 10 years, the term to commence immediately, and afterwards the lessor leased the same land, by indenture, for a term of 10 years to a stranger, the term to commence at the feast of St. Michael next ensuing, and then the first lessee purchased the fee simple so that his term was merged. It was the opinion of the court, except of Brown, that the second lessee might enter after the feast of St. Michael and enjoy his term, and c. consequently the term of 10 years merged, notwithstanding the interest termini, and the interest termini conferred a right to the possession earlier than it could have done without such merger. Again, in Doe v. Walker, A. granted a lease to B. for 21 years, to expire at Michaelmas, 1809, in December, 1799, he granted a further lease to B. for 60 years, to commence from Michaelmas, 1809. A. died in 1800, and devised the reversion to B. for life, who, in 1806, before the period for the commencement of the lease of 60 years, conveyed his life estate to C. Bailey, J. held, that the interest termini was not extinguished in B.'s life estate, observing, that B. had nothing but his life estate until 1809, and nothing but the 60 years lease after that period, meaning, of course, by that expression, that the lease of 21 years was merged in the life estate. The preceding case is also an authority that an interest termini, to commence in futuro, and which consequently does not give an immediate right to the possession by becoming a term in fact, is not extinguished by the accession of the freehold devised to the person having that inter esse termini, so long as the estate gives only a future right to the possession. An interest termini cannot properly be merged, but this right or interest, under the term, may be extinguished by conveyance to the owner of the freehold, and although an actual term would prevent the merger of the prior interest if it were an actual estate, yet if it is an interest termini only, an actual intervening term will be no impediment to its extinguishment. Thus, where A. granted a lease to B. for 100 years, to commence on the death of C, and during C.'s life B. assigned all his interest in the term of 100 years to A, the interest termini was extinguished. It is obvious that a present vested term cannot merge in an interest termini. There is not any subsisting estate in which the vested estate may merge. If tenant by elegit take a confirmation for term of his life, his estate, as tenant by elegit, is merged, and if the tenant of the freehold had charged the land between the execution made by the extent and the confirmation, the tenant by elegit shall hold charged where he was discharged before. So, if the fee simple descends to the tenant by elegit statute merchant, the greater estate will extinguish the lesser. Again, if a tenant by extent purchase the inheritance of part of the lands extended, the whole falls. This is partly on the ground of extinguishment, and not merely and simply under the law of merger. In Dighton v. Grenville, Mr. Justice Ventris observed, if the inheritance of part of the land extended comes to the connoissee, it destroys the whole extent, whereas, if a lessee for years purchase the reversion of part, the lease holds for the rest. He added, but in case of an extent, if there should be only a partial merger, the connoissee would, it is said, hold the residue of the land longer, because the profits that should go in satisfaction of the debt must be less, and this would be to the wrong of him in the reversion. But, in other respects, an extent makes an estate in the land, and hath all the properties and incidents of unto an estate, and doth in no sort resemble such an interest as is only a charge upon the land. Dighton v. Grenville is an authority for the merger of estates by extent in each other. They will also merge in estates for years, and an estate of this kind, interposed between two other estates of freehold or otherwise, will prevent the application of merger.